opportunity and speaking so much about me, which I really don't deserve. And I hope I'll come to your expectation with my all the effort. And to start, in the last 2 decades, there has been a continuous and steady increase in the number of the cases, medical legal cases, which are going to hike further due to the new CPA Act 2019-20, which is more patient friendly rather than the doctors friendly. And we, the gynecologists, rank the top. Usually, before filing a case against a doctor, a legal notice is served, and many of us must had an experience once in our lifetime. But still, most of us are still unaware, ignorant, and don't know what to do or how to proceed once a legal notice is at our doorstep. As a natural response, one becomes very nervous, stressed out, and shattered about the notice. उसकी तो रातों की नींद ही गायब हो जाती है. So today I'm going to highlight on what to do once the legal notice is served. And to start with, let me uh, introduce what is a legal notice. It is a written communication from patient or relatives of patient, voluntary registered organization, or government authority or advocate to other party demanding some explanation about the treatment given or seeking compensation for alleged energy or residual effect and or death. It also conveys the intention of the patient to file the case and take legal action. It provides chance to resolve the matter amicably. It also serves as a negotiation between the two parties. And finally, it is the first step and beginning of the legal process. I can also say that it can be taken as a last warning to decide for action or resolution. Once the case, once the case goes to the court, it continues for years with a great financial loss as well as the psychological impact. So it gives a chance to resolve the case by mutual settlement. Um, there is always a dilemma and confusion regarding the what is the difference between the summon and the legal notice. And to differentiate, it's become very important to understand between the two. Both the summon and legal notice can be served by the court, but only in the civil cases. And when the summon is noticed and issued by the court or authority, it is for the appearance or attendance of the person. While when it is the legal notice is sent through the court, it is to intimate that the allegation is filed against the person asking the party why not the case has to be admitted in the court. That is called the show cause notice. The legal notice can also be served by the private party, patient itself, or through the advocate. And the point to remember here is that there is no involvement of the court at this stage, as no legal action has been started yet. The notice can be served by email, in person, or registered post. Now, the patient can file the complaint at various places at one time, uh, at one place, or more than one place, even including the Prime Minister or the Chief Minister. And the notice can be served from the Consumer Court, Civil Court, Medical Council at both state and national council, Human Rights Commission, from the police, advocate. The point to remember is that when the patient himself can serve the notice and can draft it and send the notice without the advocate involvement. And notice, it is also important to note that criminal case do not start with the legal case notice. As I said, the notice can be served by the email, in person, or registered post. Uh, Commonly, the most common, the notice is served either in person or through the registered post, by the speed post, or through the courier. And nowadays, in the era of the digital, the email is also another way of sending the notice, and even WhatsApp can be used for it. What happens that when one gets the notice, उसके तो पाँव तले जमीन खिसक जाती है और सिर पे तो जैसे पहाड़ गिर जाता है. एक बार तो उसके होश ही गुम हो जाते हैं और उसे कुछ समझ में नहीं आता. One becomes so nervous and start panicking and tries to avoid to receive or to return the notice with various excuses like the person is not available or the person is out of station, there is a wrong address, or the door is locked. One tries to even bribe the person who has brought the notice, even the postman also. So, but the dictum remains, they never avoid or refuse the notice. Always, it will be taken. The refusal of the notice will be taken as it is served. The refusal is also deemed as acceptance of the guilt and negligence in the court of law, and later on it will be the court can call the person with summon, and the case again goes against you in the court. So always receive the notice and check the enclosure with notice, acknowledge the receipt on duplicate with time and date of receiving, and the same process has to be repeated when the notice is received through the registered post, noting the date, time, and enclosures. It's important to note that when the notice comes from the advocate of the patient, it's equally very important to check and confirm the signature of the patient or the client. Accordingly, if it is not there, one can deny to reply or can ignore the notice. Not, not defending yourself properly in case of the alleged negligence is also taken as a negligence. It will lead to wrong proceeding and precedents. Lawyer and patient will resort to claim for damages or minor issues and will hike the premium. So legally, one person is not bound to reply if there is a notice from the non-legal form or from the patient or advocate. But it is mandatory and should be always replied, and it is always recommended. A perfect reply with good evidence may close the case there and there. It again proves that one is not afraid, and again there is no negligence or fault at your end. It is also must to reply if it is a statutory notice from the legal form. If it is from the consumer court, non-reply will be going against you, and it will be in the favor to the other party. In criminal case, your silence is always against you. Usually, there is a time to submit reply, and which is around 30 days. But the time to submit the reply starts not from the date of notice written and sent, but it starts from the date and receipt of the notice by you. So the time to reply is always mentioned in the notice, and one has to follow it strictly. Usually, one must reply within the reasonable period if it is from the non-legal form or from the patient, which is around 30 to 60 days. Then one has to reply within the stipulated time if it is from the government or from any law, under any law, from the state or medical council or any other government authorities. One can always ask for some more time even from the state and medical council. In DMC, usually it is within the 15 days, and from the consumer court, it is usually within the 30 days, but it can be extended maximum only to the 45 days. The first and most important whenever one receives the notice is to inform the insurer as soon as possible, and it is a must to inform the insurer both in writing on the email and through the registered post or in person as soon as possible, enclosing the photocopy of the legal notice, summon, court notice, mentioning that this event in future can lead to the legal case. It will be then taken as a event based claim when the case, if it goes to the civil or consumer court. Otherwise, in few of the insurance, there is a claim based policy also, and which will then deny if the claim is if the case goes against you and the claim is later on put on you. And it is also important that even if you get a threatening call or on the WhatsApp message, then also it is advisable to inform the insurer even with both email or through the registered post. And the same thing should be mentioned that this event in future can lead to the legal case. Now, after receiving the notice, one has to be prepared and get ready to reply. One should never take it very lightly, as the further action will depend upon this reply only. A perfect reply is the backbone and the strongest pillar of the defense. And how to reply is always remains an art. One has to remain cool and calm. Take time to reach each word and line of the notice carefully, note down the allegation, think, rethink, and try to recapitulate the case as much as possible, though sometimes it is very difficult to recollect due to the long gap. And for the knowledge of everyone, it is important to note that the case can be filed any time up to 2 years from the cause of action. The first step is always to inform the lawyer and the indemnity insurance provider, and I have already mentioned how to do it. And now the next step is to retrieve the record and case file from the MRD, OPD, collect all the document, blood test report, consent, investigation, everything, and keep them in order. Go through the case file, each single line thoroughly, and study them properly. Do not do any alteration or change in the file, no addition or deletion to be done. Cross check all the notes, documents, progress note of all the doctors and the nursing staff, treatment given, the consent paper, and also the advice and notes of other specialty doctors of the team if they are involved in the consent. Try to find out the reason for the adverse outcome. Keep the document in order, and an action plan has to be made. Make a short summary of the important events and in the sequence and in the order related to the time and date. The first reply is what always stands for your defense, and one doesn't get a second time to rectify it. Now, never hesitate and take the help of your seniors and colleagues. It is always recommended, not that all your seniors and colleagues are your enemy. Discuss with them, show the notice to them, and take their suggestion, as their advice will be helping to you how to deal the case. Their experience means a lot, and इसमें कोई शर्म और मतलब घबराने वाली कोई बात नहीं है. Now it is time to take the references from the various literature, standard textbooks, journals, various association guidelines and protocols in relation to your defense and support the evidence. And even it is important to take out the references against the defense, because these references can be useful to counteract in the court of the law if the case goes into the court. Now, if multiple doctor and the hospital is also involved, then prepare the defense in consultation to each one, and the same will stand should be taken for defense by each and everyone. A joint or individual reply can be done with no allegation or blaming to each other. Uh, it is always better to involve the medical legal expert and the lawyer right from the beginning, from the first reply. Give all the collected references, highlighting the lines and the relevant portion to the lawyers to draft the reply. But it should be given to him only after discussing with your colleagues and seniors to whom you trust, and after it is approved by the medical legal expert. Again, I repeat, the first reply has to be very perfect, and this is the only one which stands for your defense. Uh, Here, I will like to again mention that there are two school of thoughts for the reply. One is the defensive reply, and the other is the denial reply. Defensive reply has the disadvantage as the same statement may turn out to be counterproductive. Also, the patient comes to know the defense and may alter the legal proceeding and change or alter the allegation. One should never open your own card. Then I will also like to add that after this, lastly, you send the reply attaching all the documents, numbering the pages with signature, with date and time at the bottom of each paper. I will also like to add here that there is no harm if one thinks to avoid going to the court and settle the case here only. But one should do it through the court only, and under the mediation, arbitration, and lok adalat which are nowadays available. एंड क्योंकि यदि आपने अपने चेंबर में यदि सेटलमेंट कर लिया तो फिर से वो पर्सन कोर्ट में जा सकता है और सेटलमेंट विल बी टेकन अगेंस्ट यू एज द एविडेंस ऑफ गिल्ट and reply. I like to stress why it is important to um, uh, include the medical legal expert and the lawyer from the very beginning. The medical legal expert uh, knows it's the bridge between the doctors and the lawyer. As the lawyer, they don't have much knowledge about the medical knowledge, and similarly, we doctors don't have much knowledge about the law. So the medical legal expert bridges between the two, and he bridges the gap and does the cross checking of the documents and references. The ground of defense is important, which is guided and prepared by the medical legal expert, and that is also for the lawyer only. The lawyer only looks for the legal cases on the other side decided by the different court, which can be used as a references and can be quoted for the reference. Lastly, the drafting is done by the lawyer in the legal language, and as I said earlier, the documentation and presentation with drafting remains very important in reply, and the first reply has to be very perfect. At the end, I want to quote the statement made by the Justice Markandeya Karju, who has made the statement that law is a watchdog, not a bloodhound. Sorry for the wrong spelling. And if the reasonable care is taken, the doctors will not be held negligent. And if you don't get a notice, you don't do the practice. So I hope after my talk, there will be no need to fear, and one will not get afraid and will not get nervous. And once if they get a notice, and they will be well prepared to reply with the perfect drafting. Thank you so much for your all patient hearing.